Hi everyone, this is Mark Masters. Welcome to the open and obvious installment of our Michigan 2022 Premises Liability Series. I'll be presenting the chapter on open and obvious today, and as I was preparing it, I just brought up a slide this is a picture I actually took in the late 90s when I was doing this seminar for the first time back then. This is actually a picture of my house, or my house then at least. The porch was deteriorating. I got to a little bored, I guess, one weekend and decided, I'm going to knock this porch out of here and put in a new porch. And so I did the demo, took a sledgehammer, smashed it all up as you see. And while I was waiting for all the new blocks and cement and everything to come in from Home Depot, I'm a paranoid new lawyer at this time, so I had roped off my front porch area with that yellow caution tape you see strewn all about, here, I'll use my cursor here, all along the bottom of the photo. Right, like a good citizen, because I know all the crazy people that sue for stuff they shouldn't sue for because it's their own fault, so I'm going to protect myself. I come home from work the following day, and as I pull up, I can't believe it, as I pull up in my driveway, I see this, which, again, follow the cursor. It's a little pizza delivery coupon. So those guys that walk through your yards and drop all this stuff and rubber band them to your door handles, someone had come and not only crossed my little safety yellow line here, crossed all through this stuff, climbed up here. This is dangerous as heck, but it's climbed up here to rubber band this thing up on my door. And that, as I said 20 some years ago, these are your plaintiffs. This is the stupidity of what people will do, no matter what you do, caution tape, everything else, and they still do it. Well, flash forward to about a month ago, new house, needs a new porch. And this time I, hire somebody to do it, and they have all this stuff, delivered. They smashed up the old porch, the old walkway, and they even put up cones. I didn't even ask them to. The contractor just put up their own cones, all these yellow orange safety cones. And again, I come home from work, and lo and behold, the Amazon delivery guy walked through all this mess over the paver. Nothing's like cemented in place yet. Life into their own hands to drop off this package for no reason. And this is something they can avoid, because back when I was in Royal Oak, another issue I had was I had a bird nesting near the porch, which was dive bombing the mail carriers. Post office refused to deliver anything for a while, and yet they won't deliver then, so they have the choice. They don't have to deliver. This guy has a choice. This gal has a choice. Oh, and then this next slide, which just advanced, same thing. I come home a day or two after the first package delivered, and someone's done it again. Another delivery person walked all over all this stuff and threw this thing in the middle of the construction area, despite cones, obvious danger, obviously not a good thing to walk on, and they did it again. Now, again, I mentioned before this whole idea that, that people argue, I had to confront this issue. So these people don't have to confront this issue. And I want to show you a picture which I took about 2 months ago because I thought it was funny before we had the porch smashed up. This is the Amazon delivery guy. A month before we had the construction started, they throw this box, they barely kick it out of the back of the truck. Right? So there's no urgency for them. There's no need. We got to get it to the front door. No, they just throw it out the back of the truck. They could care less. So these people, it's like they always make the worst choice, the most wrong answer. When the porch is fine, you can walk on it. The walkway is fine, you can walk on it. They just throw stuff on my driveway. But when we have orange cones up, every warning, don't cross it. Nevertheless, they decide to venture on. And here's a little juxtaposition of all these photos. So again, I guess my point here is, in the 20 years I've been lecturing on this very subject, the human race has not gotten any smarter. And that's why we're busy. That's why you're busy. Because people simply don't take appropriate care for their own safety. And they do it all the time. And trust me, if one of these bozos broke their ankle or slipped and fell, I'm sure I'd get sued. And been yelled at by my wife for us getting sued. So let's talk about a little bit of background here. So assumedly most of you have some basic understanding of lawsuits, definitely have an understanding of claims, and the four key components of any negligent action is the plaintiff has to establish a duty. We should have done or not done something, to protect the plaintiff or make sure they didn't get hurt. The plaintiff has to prove that the defendant then breached that duty, which is commonly referred to as negligence. 3, that breach, that negligent act, had to be the cause of their injury or damages. And number 4, they suffered damages. The open and obvious defense focuses on the duty issue, that first element. And we look at, was a duty owed? And typically there is, right? There's a duty in general not to hurt people. There's a duty that you take appropriate care for your safety, and you take some degree of care for others' safety, depending on the relationship. Other people in the series will talk about invitees, a business invitee, or a social guest, which is called a licensee or a trespasser, and the different duties for that. But for open and obvious, it's a case killer for no matter if it's a trespasser, if any duties owed to a trespasser at all in very limited circumstances, a business guest or an invitee or a licensee. So the open and obvious issue goes to the heart of duty. If something's open and obvious, the defendant, the premises possessor, does not owe a duty to that injured person. And as explained by case law, as you see on the slide, it's a simple question: whether a reasonably careful person, upon casual inspection, would be expected to discover and avoid the hazard. And then a danger is open and obvious if it is, quote, it is reasonable to expect that an average person with ordinary intelligence would have discovered it upon casual inspection, unquote. You think it's a simple issue, and it often is, but sometimes, with a properly coached plaintiff, they will muddy the waters. Honest people tend to get their cases dismissed because an honest person will say, well, yeah, I should have seen that brick on the ground. It was light out, or there was at least enough light to see, or I should have been watching where I was walking. Because the fact of the matter is, you weren't watching where you were walking. Because if you're watching where you're walking, sir, you would agree with me, you would have seen the brick. Yes. You would agree with me that you would have walked around it. Yes. Or over it. Yes. Or simply not encountered it if there's some kind of hazard where it was bigger than a brick, something bigger, right? You would have just gone a different way, come back later, and so on. Yes, 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 yes. And because obviously, as we sit here now in hindsight, if you had to do it all over again, you would never try to walk across this brick or this defect or this problem or this ice or whatever, because you don't want to break your leg. And certainly it wasn't worth the 30 seconds of time you save by going directly across rather than around in exchange for breaking your leg and so on. So they're usually, an honest person will typically agree with you, and the dishonest person, you usually can make them look like a fool or a liar when they explain, oh no, I still would have done it. Really? Even with the broken leg? Of course not. Now, I just talked about looking back when we talked to the plaintiff in their deposition about, sir, you agree with me, you wouldn't have gone this way. But plaintiffs are not allowed to do this on a duty analysis. There's no Monday morning quarterbacking. Now that the accident is over, you can't go back and in theory or in retrospect, was this dangerous? You're not allowed to do that. You have to look at it at the time. At the time, was it really dangerous? Should someone have seen it? Is it something that the ordinary prudent person would have seen and avoided? You don't go backwards, looking at it from backwards. You look at it from the moment it happened. Now let's talk about this general rule, right? The ordinary prudent person taking care of their own safety. Would they have seen it? Would they have avoided it? So we start diving down into all these different variables. We're human beings. There's a million variables. These are the common ones that come up. One of the most famous ones that everyone on the plaintiff bar complains about is this case, Sidorowitz, and I'm probably saying it wrong. It's a chicken shack case. The plaintiff was blind. And they're like, wait a second. So therefore, the argument by the plaintiffs, this guy's blind. How could he possibly have seen this? He couldn't. He's blind. Therefore, it's not open and obvious. And the courts again say, no, this is an objective test. We don't look at it from the perspective of this particular injured person who may be blind. We look at it from the average person. An average person of ordinary intelligence. That's what we're looking at. And so the average person has sight. So therefore, we look at it from that perspective, not from whether or not this individual has some sort of disability, which in this case, blindness, or another case, some reason they shouldn't see or observe something. So, nope. Disability, not a factor. What about people who are drunk? They have diminished mental capacity due to alcohol. No, same thing. It's not our job, even if we're a bar, to protect drunken people who are high, or whatever the problem is. No, it's the average, ordinary, prudent person who should be taking care for their own safety. So we don't have, no special duty applies to drunks. What about people with diminished mental capacity due to age? Yes, this is actually an exception. And this is a case of Bragan. They said that, it's different from minors. So if you're a minor, 17 and a half years old, you're a minor. My oldest is actually that age and smarter than me, but but she gets a special exception for now, for the next few months, till she turns 18. We look at that particular minor from their perspective, from like age, experience, and intelligence. So if you got a 12-year-old, we look at it from what would the average 12-year-old have known or seen and done, or if they're 17, or if they're 6, and so on. And again, I'm going to remind you, this is not a negligence analysis, because I've had cases where the injured person was a child. And so as you probably all know, a child of tender years, 7 and younger, or under 7, cannot legally be found to be negligent. They are negligence-free according to law, or at least they can't be saddled with comparative negligence, for instance. And so I had a case years ago where the kid fell off a above-ground pool ledge and did a belly smacker on a driveway. And the plaintiff's attorney, in response to the motion, was arguing, well, open and obvious doesn't apply because he can't be held negligent because he's too young. Well, that's not a factor in the open and obvious analysis. This is not looking at it from a perspective of the kid negligent. It's not looking at it from the perspective of was the kid comparatively negligent. It goes to the duty issue for the homeowner in that case of did they have a duty to do something different here. And in this case, again, the deposition is always key. And I love kids in general. I love deposing children because they are typically more honest than any adult you'll ever meet in your life. And just with proper questioning, they will tell you the truth. And I forgot what the kid's name is. It was years ago. But, okay, Billy, at the time you were there, you've been in the pool before, you've been on the side of the pool before, and you knew that you could fall off the edge of the pool. Your mom had warned you on prior visits to the house that you could fall off, be careful, etc. You knew all that before this day you fell off the pool? Yes. And you knew that before this happened even, you knew it was high off the ground, it was 4 feet off the ground, you knew you could fall and hurt yourself? Yes. You knew you had to be careful? Yes. You knew this all before you got on the edge of the pool that day? Yes. Your mom had told you many times, be careful, etc. Yes, yes, yes. And Mrs. So-and-so who owned the house, she told you the same thing? Yes, yes, yes. You knew you could fall off and break your leg? Yes. You knew you could fall off and be hurt even worse? Yes. So you knew those things before the accident happened? Yes, 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 yes. Perfect. Because now we don't have to get into an argument with our judge or with the plaintiff in front of our judge to say what this kid should have known from his average age, the average smart 6-year-old. We can say, hey, judge, look, Billy here himself admitted in his sworn deposition under oath, because now he's 12 or something by the time the lawsuit gets filed. So now Billy's already admitted all these things. He admitted what he knew. He admitted what he was aware of. He's admitted that he had been warned by his mom and he'd been warned by Mrs. So-and-so who owned the house. Billy knew all these things. He said so. He told us. Therefore, boom. And the judge agreed with me. Case dismissed. But that's a tricky one with the kid. So now that kid's case leaves open the issue of, well, what about other kinds of diminished mental capacity? What about people? What about someone who has a mental disability, born with it? Or maybe a bad head injury over time, or dementia, or Alzheimer's. Those are all open questions. And I guess the issue on the defense side, which cuts in favor to the defense in those sorts of cases, is the person might be unable to testify. They might be unable to communicate. I had a case years ago. It was an elderly man, and he had a trip and fall allegedly. And I say allegedly, it was unwitnessed. It was reported to the apartment complex afterwards. But then somewhere between the time of the supposed accident happening and the time a lawsuit gets filed, he had dementia and he had it bad. He couldn't communicate. He couldn't remember anything. And suddenly they don't have a case because now he can't tell anyone what happened. And the argument, he told the insurance company representative, they took a statement from him. He said what happened then. Well, as I explained to the plaintiff's attorney in the court, well, that's all really interesting. It's inadmissible hearsay. I can use this statement under the rules of evidence because it's offered by the other party. He can't offer it himself to support his case when he's now, he not claim, he just couldn't barely speak. So the statement was not coming in. And so suddenly now the case, how do they get their case in that there's a defect, that he fell? They have just all those initial proof problems that they have the burden of proof on. That case we actually settled on the cheap because of those problems. But if they have some kind of disability where they can still communicate, if they can remember and so on, you're going to be going down a tough road as far as winning a motion to dismiss in front of a judge, because the judge isn't going to want to step in and say, well, how do I qualify this with, a person with the plaintiff's this stage of dementia or this kind of disability, or where they fall on a particular spectrum if they have a disability and so on. Very difficult questions, which I'm sure the judge will find as a fact question and punt to the jury. So just be aware of that. The latest and greatest decision on open and obvious is the Lugo versus Ameritech decision. It really spells it out. It's actually very strong for the defense and has been for quite a number of years. And the quote at the bottom of the slide says it all: where the dangers are known to the invitee or are so obvious that the invitee might reasonably be expected to discover them, an invitor, which is your premises possessor, usually the property owner, owes no duty to protect or warn the invitee unless he should anticipate the harm despite the knowledge of it on behalf of the invitee. So basically it just says in more complicated language what we've known for many years before this from prior decisions. It's your ordinary, prudent person taking care for their own safety. Now, Lugo carved out a couple of infamous, I call them special aspects. They say, well, even though something's open and obvious, there are two exceptions, Lugo says, that apply that would take it out of the open and obvious, which are if the hazard, whatever it might be, is effectively unavoidable, or number two, unreasonably dangerous, even though it's open and obvious. So it's unreasonably dangerous such that special aspects impose an unreasonably high risk of severe harm. So what do those mean? Let's talk about effectively unavoidable. That means the plaintiff's in a position where they must encounter the hazard. The classic example is some puddle of water, right? Or ice or snow that they're surrounded. And there's lots of cases that talk about what is or is not effectively unavoidable. Some of them find in favor of the plaintiff. There's the Blue Oil case, which is a plaintiff goes to a gas station, and the Court of Appeals in that published decision said, well, they had to encounter the ice to get in the gas station, which doesn't make sense because actually it goes right against the decision in Lugo itself. And Mrs. Lugo, was saying, well, she was forced to confront the potholes in Ameritech's parking lot. And that's what she was saying, it was effectively unavoidable. But the Lugo decision said, actually, well, no, it was avoidable because you didn't have to go into the place. You could have left. You could have stayed in your car. You could have gone back to your car if you didn't discover them until you got outside of your car and left or come back another time. This is just some business. You're not required to go in there. You're not required to confront this situation. So effectively unavoidable is often very fact-driven, and it's always very key in the statements you might take, recorded statements you might take from a claimant, and depositions that we would take. First of all, you need to think of it in the three physical dimensions. Up, down, left, right, forwards, backwards. Can you walk around it? Can you walk over it? Can you walk through it? For instance, the through it issue, can you walk through it safely? I live in Michigan. Most of my plaintiffs are from Michigan and have lived here a long time. Those are always fun questions, right? On snow and ice case. Well, you know what snow and ice is. You live with it all the time. You've been alive 68 years here in Michigan. You've been through 68 Michigan winters of varying degrees of severity. Snow is slippery. Ice is slippery. There's often ice under snow. Slush is slippery, melting and freezing, etc. You participate in every kind of winter sport. Skiing, sledding, ice skating, probably hockey, figure skating. All these things are slippery. You've walked on ice a million times in your life, ice fishing, and so on, tubing. All these things. And you've walked across snow a million times in your life without any problem. Sometimes slipping and sliding, but you're careful, right? Even walking across a hockey rink just in shoes, it's all ice. Or an ice skating rink, or a frozen pond. You've done this a million times, or ice everywhere, right? In your homes, your driveways, everywhere. You face this all the time, all winter long for 68 years. Done this a million times. And this is the only time you've fallen? No. Maybe it is, maybe it isn't, but you got hurt. You knew about all these things beforehand. You knew how to walk over ice safely. You knew how to walk over snow safely, etc. You could have walked around it. You could have walked over it. Did you come to the business? Did you call out for help? If you're in an apartment complex, did you call the office, call maintenance, have somebody come out, salt it? Where were you going that was so important? Why did you have to come inside that was so important? What was the issue? Especially now, all the things we learned from COVID, anything can be delivered. Anything, including your prescription. My pharmacy delivers within like an hour. It's great. And they only charge you for the delivery. So there's no reason you need to go anywhere anymore. So that, I think COVID in that regard has strengthened this defense, I think. And don't forget, again, I would put here, don't forget the fourth dimension for you budding physicists out there. Time is also referred to as the fourth dimension. Time would fix this problem in most cases, and snow and ice certainly. You could have waited. You could have waited in your car. You could have waited in your apartment or whatever. You didn't have to go, right? It wasn't that important. Now, it's different if it's an emergency, they're having a heart attack, they need whatever. Those are all very rare, but it's usually, no, I just wanted to go to work, or I wanted to do this, or I wanted to go to the store, or I was coming back from the store, I was coming back from work, or whatever the issue is. You could have waited. You could have stayed in your car. You could have chosen a different route. You could have gotten salt. You could, whatever. Heck, go to Home Depot and buy a bag of salt. Why? This is not unavoidable. So anyway, that's all the little bullets I have below, which we just talked about. Uniquely high likelihood of harm or severity of harm. Well, Lugo helps us out itself. It says in the actual opinion that falling from a standing height doesn't meet this exception. It's not a high degree of harm. It's not a high severity of harm. Human beings in horse races were the only creatures which trip over our own feet. I've fallen plenty of times. I just fell the other day because my feet got tangled up at a tablecloth at a high school graduation party, and I fell right on my behind. But that was totally my fault. And my ego was bruised. I think I had a bruise on my behind, and that was it. But certainly no severity of harm or high likelihood of harm, just falling from a standing height, as Lugo says. Lugo uses the example of, well, what would be this uniquely high likelihood of harm or severity of harm? They say falling into a 30-foot deep pit is the court's example in there, which wasn't at issue in Lugo, but they threw that as an example. So that's sort of the standard. Since then, and this doesn't get a lot of press for some reason, and I cite this in every open and obvious motion, there's another Supreme Court decision which came down shortly after Lugo, which you see on this slide, which is Perkavic versus Delcor Homes. In that case, Mr. Perkavic was a roofer, and he fell off a 20-foot high icy roof, and it was held to be open and obvious. Well, therefore, fall from 20 feet apparently doesn't meet the exception. So we look at Lugo and it talks about this 30-foot deep pit, and which was really dicta because it wasn't an issue in Lugo. And then we look at Perkavic, another Supreme Court case, which is 22 years old this year, says falling off a 20-foot high roof is still open and obvious, case dismissed. So therefore, the high severity of harm exception doesn't apply. So now that magic distance is somewhere between 20 feet and 30 feet. And I have yet to have a case where someone fell more than 20 feet. They're usually falling off either just at a standing height, or they're falling off a curb or a few steps. So they never come close to hitting that 20-foot Lugo decision. So it is an exception. That's a tough one for the plaintiff, unless they're falling on something that's like going to stab them. Another attempted exception, again, there's just two spelled out by Lugo, and that's all there are. There are just two. Plaintiffs' attorneys keep arguing, and I still see this every once in a while, this fake, and I call it fake because it's just a lie. They argue there's a shopkeeper's exception, meaning, hey, my plaintiff's in a store, we're at whatever, hardware store, grocery store, whatever, and you, the premises possessor, the storekeeper, the store owner, you are purposely trying to distract my attention with all your shiny, bright displays. So all the products you have on the shelf, trying to grab my attention that you guys, the manufacturers of these items spend so much time and money in, having psychiatrists and psychologists examine how to grab my attention. So I look at your product and I, look at your display, and you're distracting me from looking at the floor. You're doing this to me on purpose. That dog won't hunt, as they say. This is not an exception, even though it's tried. And And the case that the Court of Appeals finally came down with, Kennedy versus Great Atlantic, you see it here cited. No, sorry. It talks about this specifically. This is not an exception. Open and obvious is spelled out by logo. That's the rule. There are two exceptions. Unavoidability. You don't have to walk. And often these people, they walk into the display or they trip on the display, which I think is particularly humorous. Says no. So this shopkeeper's exception, it just is simply inapplicable, doesn't exist. It's a lie. So we're not going to listen to it. I also know, too, the clothing rack cases, because I had a case recently where a person is claiming they tripped onto one of the clothing racks. There's a whole bunch of cases. I didn't realize so many people tripped on clothing racks in stores, all the display racks, with the dresses on them or suits or pants or whatever. They'll trip on the things. And I think that, again, is just comical. Like, what? I don't understand what you people are not understanding. So you'll see that a lot. And, you're trying to distract me with all your pretty clothes. No. Next thing is, which defendants can assert the open and obvious defense? It's not available to everyone. Because you have to look at premises liability in general. The people the defendants who owe those premises liability duties are ultimately the possessors of the land, who may or may not be the owners of the land. I know a lot of times case law uses possessor and owner interchangeably when that's not the issue, but if there is the issue of who has possession, it really pivots on the possessor of the property, or the one who owes those premises liability defenses. For instance, if I am a landlord out of possession, let's say I have a home I rent out, an Airbnb or something, and I'm renting out my home to my tenant, the whole place, and then the lease says, look, you tenant, you have the whole property. You got to cut the lawn, you got to shovel the snow, etc. Deal with it. That tenant is the one who owes people, their visitors, those premises liability duties. The mailman that comes, the UPS guy, the plumber, whoever, that's to whom they own the duty. Me, as the landlord, I might have rights of re-entry and repossession if they don't pay the rent, or I need to make an inspection or whatever else. Doesn't matter. The right of re-entry isn't enough. So I'm a landlord out of possession. I don't owe any duties. I can't be, I'll get on an emotion. I'm sorry, not in possession and control, not me. Look to whoever's in possession and control. It happens usually in commercial properties, strip malls, etc. Those kinds of leases, but occasionally in residential rentals as well. So, as a result, if only those premises liability duties apply to the possessor, only the possessor can use the open and obvious defense. Now, don't get me wrong, I'll still raise the defense if my client doesn't have possession and control. I'm raising that defense, and I'm going to pursue that defense too, amongst others. It's because it's a very powerful defense, and courts like it, and they enforce it. And so a lot of times plaintiffs don't even think to raise the possession control issue if I'm a landlord out of possession or something like that. Sometimes you run into a subcontractor situation, which, again, some smarter plaintiffs' lawyers are onto this. So let's say you have a snow removal contractor. So plaintiff slips and falls on snow and ice in the parking lot, sues the premises owner / possessor, say it's a strip mall, for instance, and they'll also sue the snow removal contractor. Well, the snow removal contractor, while they have other defenses, which are discussed at least in the third-party contractor section of this webinar series, in addition to other potential defenses, the snow removal contractor does not have possession and control of the property. So therefore, they don't get the open and obvious defense. So they're just a straight negligence claim. And again, there's other defenses which will be discussed in other portions of this series. But it's important to remember. So when thinking about your client, your insured, or yourself, if you're a property owner or a company that owns or possesses property or manages property, you need to decide, well, does this apply to us at all? In the consideration of whether or not we want to, consider paying a claim or not. And sometimes you run this issue of a construction site. So you have a general contractor, you have different subcontractors. That's the Ghaffari decision. You see another Supreme Court decision that I've cited on this slide, where the plaintiff was one subcontractor, tripped and fell over a bunch of pipes left on the construction site by the plumbing subcontractor. The plumbing subcontractor wants to argue, well, it's open and obvious. The court says, well, no, because the plumbing subcontractor isn't in possession and control of the job site. So therefore, they don't get the open and obvious defense. They have other defenses, but they don't get the open and obvious defense. However, the owner of the job site and the general contractor may be entitled to the open and obvious defense, given the right set of circumstances. And frankly, not in this case, but in other cases, depending on the facts, a subcontractor might be entitled to open and obvious offense. Let's say you have a huge project. Let's pick, I don't know, let's say you're building a shopping mall. And so let's say one of your subcontractors is responsible for building out the Apple Store, an Apple Store alone. And so that subcontractor is building out the Apple Store with all the computer stuff they need in there and the Wi-Fi, etc. And some other subcontractor comes in there to do whatever, paint, and has their accident. Well, that subcontractor who's doing the Apple Store probably can claim the open and obvious offense because they're in possession and control of that defined space within the overall construction project. Or maybe they're in control of that defined space for a certain amount of time until they're done, and which would include when the accident happens. So you look at who had possession and control. It might be multiple people of that site where the accident happened at the time it happened. Let's see. Now, common plaintiff strategies to overcome the open and obvious rule, and the typical one is I didn't see it. I didn't see it, which, number one, might create a different problem on lack of notice for the plaintiff. If they didn't see it, why should I, as the property possessor, have seen it? If typically the black ice, right? It's invisible black ice. Well, that's always a fun bunch of questions. So it's invisible. Right? Could you see it from a standing height? No. And you go through their eyesight and everything else. Basically establish there's no way anyone could see it. And they ultimately admit, so sir, you would agree with me that what you found was invisible, correct? Yes. Okay. So then you roll right into your notice defenses. How long was it there? Since you couldn't see it, you have no idea how long it was there. Since you couldn't see it, you have no idea how big it was. And then, now sir, when you were laying on the ground after you fell, did you then see the ice? When you're laying on the ground? No, still invisible even when you're laying on the ground. Because the arguments I'm going to make to the judge later, well, Your Honor, plaintiff had 20/20 vision. This was daylight. They said it's invisible from a standing height. And even more so, when they fell flat on their face, when Mr. Plaintiff fell flat on his face and his nose is on the ground, on this very invisible ice, he says it's still invisible. How can my client be expected to ever find this? Even crawling around on their hands and knees over the property, which there's no duty to do, crawling around on their hands and knees still would not have revealed this invisible claim defect. And of course, you have no idea what formed this ice. You don't even know if it was water or coffee or something else, because people dump out water bottles. You don't know the source of it. You don't know if it came from falling from the sky, if someone tracked it on their shoe, if it dripped off of someone else's car as they arrived at our parking lot, it dripped down, and so on and so on and so on. You don't know the source. You don't know how long it was there. It's invisible. We couldn't have seen it, so now maybe my open and obvious offense isn't going to work. But certainly now he got another complete case killer on his hands, which is they can't prove notice, which is again discussed in another section. Other witnesses, did anyone else see it? Did you see anyone else trip and fall or slip and fall before your accident occurred? So no one else has seen it. Sir, you lived at this apartment building for 10 years beforehand. You never had a problem, never complained of a problem, unaware of any of your co-tenants, etc., 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 etc. All good for us. What becomes a problem is people will say, oh, this defect was caused because there was a leak from the roof, or the gutter was dumping out water, or this was an area which repeatedly, I didn't know this because I'm a visitor to this property for the first time. But when I got there, as my lawyer figured out later, there's these defects which cause a reoccurring problem here. And so therefore it's invisible, but you guys created it, or it's been ongoing at the property and so on, that's why I can't see it. Those are the cases you're going to have trouble with. I didn't see it because I was distracted. Again, we talked about the shopkeeper exception, or what was the distraction? So the second part of the slide, again, the fake shopkeeper's exception doesn't exist. Or in the Lugo decision itself, Mrs. Lugo said, well, she didn't really notice potholes in the parking lot because she was walking through the parking lot, so she was trying to avoid traffic so she wouldn't get hit. That's why she wasn't looking where she was walking. And the court said, no, that's simply not good enough. You need to be watching where you're walking. You should be stopping if you need to watch for cars or whatever. There's no way around this. You got to watch where you're walking. There's two pivotal companion cases of Maurer versus Oakland County Parks and Recreation, which is also paired with the Bertrand versus Allen Ford case, Supreme Court case before Lugo, and they're trying to juxtapose when is something open and obvious, when isn't. And in the Bertrand versus the car dealership section of the case, they said that the alleged defect was what was characterized as a bizarre arrangement of doors and stairs. I never saw pictures of it, but apparently, in this waiting room area at the dealership, when you walk in through one door, it goes down a step and up a step and around, and it's just some kind of confusing little arrangement that the court said, well, no, in that case, we're not going to say it's open and obvious because it's this bizarre arrangement of steps and doors, which I don't know if that's going to stick nowadays anymore under the Lugo decision and all the cases that have followed. I didn't see it because it was invisible. We talked about this a little bit as far as the ice and snow goes. But plaintiffs, sometimes something is kind of invisible or very hard to see. This Pippin case, from 2001, some landowner had put up a chain across his parking lot so he was trying to keep kids from cutting across his parking lot all the time, especially on bicycles, and it clotheslined some kid. So the Court of Appeals said this was a question for the jury, whether or not it was open and obvious. I don't know what the ultimate outcome of that case was, if it settled, went to trial, etc. But from the Court of Appeals level, they got to, they got a conspicuity expert, which is a smart plaintiff attorney, saying, factors, this thing is hard to see with the surrounding circumstances, and the chain itself kind of blends in camouflage, and it's not something you normally expect, and so on. So those are things you have to be careful about as well. Ice, you talked about ice under snow is open and obvious. Another Supreme Court case. The Supreme Court cases are very hard on plaintiffs with snow and ice cases. Talk about indicia of Michigan winters. You're familiar with Michigan winters. You know snow and ice. The weather conditions, that things melt and refreeze. You should suspect that there's ice under snow, or you should suspect there's black ice out there because, again, the weather conditions are beginning above freezing, below freezing. There was precipitation the last couple of days. You can see there's snow on the grass, even though you can't see there's snow on the pavement. You know what's happening here. You're not a fool. You have to take appropriate care and walk carefully. We can all walk over black ice and not fall. We do it all the time. But nothing special about black ice. It's ice. It's just harder to see. That's all it is. And in these kinds of conditions, the court's saying you should be watching what you're doing. You should be more careful. Every indication is out there for you. You should be more careful. This is your fault. You're not going to get to sue the defendant for this. And then another one case that got around it, there was a case, I don't have the site on here, it's in the materials. It was hard to see water on the floor. There was a rug present. It was raining outside. Those cut against the defendant as far as being able to see things. Black ice we talked about, it's a maybe issue a lot of times. It really turns quite a bit on that deposition testimony. And if you run into a situation, and again, it happens every time, we're going to talk about this in a case I have in a second, where you get great testimony from the plaintiff, and then afterwards, usually after you file your motion to dismiss, the plaintiff's attorney in response files an affidavit from their client or an affidavit from an expert of one sort or another saying why it's not open and obvious. That doesn't fly. That testimony of the plaintiff is so key. Again, we talked about this quite a bit already. Wintry conditions, being aware of surroundings, weather conditions, and so on. I didn't see it because it was dark. This was one of my favorites. I've had tons of these cases. You have as well. The case law goes both ways. But again, it really depends on the facts and how they're developed. My position always is darkness itself, by itself, is an open and obvious condition. If you're deciding, you open a door and the room you're going to walk into is pitch black, or whatever it's in, who knows what's in there? Who knows if you're going to be walking off a 10-foot loading, or not 10-foot, maybe a 4-foot loading dock bay or whatever. But cases vary. And there's a loading dock case. And so, the plaintiff shouldn't have predicted there was a loading dock there. Some of them deal with steps, landing areas, etc. But there's a Singerman decision, which, again, I don't think gets a lot of press. It's a Michigan Supreme Court case where the court held that inadequate lighting may constitute an open, obvious condition in and of itself that an invitee may reasonably be expected to discover. That's Singerman. And in Singerman, this is bizarre. This is a guy who's playing hockey at a hockey rink. And he takes a puck to the face. And he's like, well, the lighting here was kind of dim, and if the lighting was better, I would have ducked. I'm not kidding. This was the claim. And it made it all the way to the Supreme Court. And here the court, for me, I would really focus on, my focus is on, no, it's dark. Or it's dimly lit. You knew all these things beforehand, and yet you decided to soldier on. So after that point, it's as if you're blindfolding yourself. You've chosen to do these things. No one was forcing you to play hockey. But in the Singerman case, they talk about the fact, well, in that case, the plaintiff, he admitted he'd been to the rink before. The lights were not fluctuating. It's not like they were going suddenly dark and suddenly dim or whatever else. He knew what the lighting conditions were. He voluntarily chose to play hockey. He knew the dangers of the sport of playing hockey, including taking pucks to the face and needing to be able to see what's happening and dodge and so on, and soldiered on. And so this little quote here I have is, from my case actually, is Roman versus Desert Oasis, which just got the dismissal on the open and obvious offense just got affirmed a couple weeks ago. Obviously, I'm very happy. So let's talk about Desert Oasis. Desert Oasis is this darling little coffee shop in downtown Rochester. My wife and I have been going there for years before I ever had this case. It's great. They usually have on weekends live performers. It's close to Oakland University, so a lot of times they'll have college kids or they're playing a guitar or singing a little bit. And one will do a couple songs, they'll switch, and it's great. I love this place. And downtown Rochester is wonderful to go visit. For those of you not from Michigan, if you're here, go check it out. Lots of cute restaurants, little bars, and this little cute coffee shop. And so, this picture in the upper left-hand corner, this is a picture I took after I got this case in. This is right when COVID started happening, so they got all these little signs up now. Because I get this thing in, and the plaintiff, you can see there's a transition, there's a step here. You can see a little bit better in the other photographs here. There's a step up from the gray sidewalk up into this little piazza, like a little porch area before you walk into the physical coffee shop. And they usually have a couple of tables. You can see them. There's a couple of tables out there. And so this plaintiff, she's an older lady. I think she's around 65, 70 years old. She's diabetic, has problems with diabetic blindness, night vision problems, the whole 9 yards. And she, downtown Rochester during Christmas time is even more beautiful because all the buildings along Main Street are just coated in Christmas lights. They hang them from the roof, each roof, and so it comes straight down, and each little business is a different color, and it looks like something out of a storybook. It's gorgeous. And they have these little Winterfest days, and she's down there with her daughter and son-in-law and some of their friends for this little Winterfest thing in downtown Rochester. Lots of people around. And so this gal trips and falls as she's walking from the side. She's going in to use the bathroom, so she's an invitee, not going to buy anything, but she's going to use the bathroom. It counts, so she's a business invitee. These three photographs on the right were all taken by plaintiff's son-in-law that night. And because when I got this case in, I'm like, wait a second. I know this place really well, and I know downtown Rochester pretty well. They have all these big street lights, this big green street light you see. And I know there's one dead set in front of these steps, and the street lights in downtown Rochester, they hang over the sidewalk. So this is close to the curb, the post, but instead of hanging over the street, probably because of truck traffic, right? The light hangs over the sidewalk. And as you can see in the photograph the plaintiff takes that night, this middle one, second from the right, her son-in-law takes, that light's on, right there. It's like a ballpark light. It's like 1 billion watts. And as you can see also, you can see now, these pictures taken that night, I believe this is the plaintiff sitting there at the table being attended to by one of her friends, or her kids' friends, while they're waiting they call the cops too. It's ridiculous. But you can see there's one photo they take, so one of the companions stands next to the step to show the drop-off. Number one, thank you so much, plaintiff and plaintiff's friends, for taking all these awesome photos for me, which I think helped my defense so much. Here at the top of the middle, you can see a little bit of the red light, Christmas lights hanging out. Number one, it shows the contrasting color between the steps and the sidewalk. And by the way, if they're all cement and all the exact same color, they'll argue it's camouflage, but the case law is very clear. Nope. That doesn't get you past open and obvious events either. Even if it's all cement and the steps are the same color and they're camouflage. Nope. You should see the step. In this case, very different colors. And not to mention this guy standing here, you can see how bright this light is from the street light shining. It's like a ballpark. Look at the shadows that are cast from this light, how bright it is. And In addition, you can also see these this is interior now to the this little piazza area before you walk into the physical coffee shop. There's these display cases from the next door businesses. I think it's a jeweler on one side and something else on the other. You can see these like little things, because this is all covered with roof inside this little piazza area, and there's lights up on that ceiling, and you can see all those ceiling lights around, because you can see they're all pouring light down on the tops of these little roofs above the display cases. This thing is awash in light, and it's just ridiculous. And it's like, as soon as I get the whole time, plaintiff, they want some stupid amount of money. We offered like nuisance value, obviously, because the case is so worthless. But again, people aren't getting any smarter. They're still not taking responsibility for themselves. I don't, like in this case, this is some nice woman. She's a very nice lady. Just blaming the coffee shop for everything. She takes zero responsibility for herself. It was ridiculous. And normally when you get like this, get to the greatest generation, usually they're great plaintiffs for the defense, because usually, number one, they're very honest, and they just by nature take responsibility for themselves and everything else. But not this lady. This was, according to her, all our fault, which it wasn't our fault at all. So I encourage you guys to go by there too when you get a chance. It's great. I don't drink coffee. My wife loves the coffee there. I always get hot chocolate and cookies. So next one. I didn't see it in my expert agrees. In the Vroman case, they coughed up an expert from one of the noted plaintiff building code experts who said that the step violated 100 building codes, although he couldn't cite any one of them. He cites some kind of fire code that the thing should be painted orange under a fire code, but of course it doesn't apply. There's no fire. It's not a fire issue, and so on. And just because they come up with some, expert or scheme or theory that you violated a building code, that doesn't matter. A building code violation does not trump the open and obvious offense. It doesn't matter. Number one, the step was grandfathered in a million years ago, so this expert was so far off base anyway. In my Roman case, it was just stupid. But even if it was correct, even if there was a building code violation, it doesn't matter. It's really interesting, but a building code doesn't create a duty, especially a lot of times these plaintiff experts will fall back on the general. There's building codes, right? There's all these heights and measurements, and everything has to meet certain criteria, how high a banister is, how high each step is, how wide each step is, how much differential is allowed to be between one step and the next step to avoid tripping hazards, and so on. You will almost never find a staircase that's within code. You will never find any property that's in code. I mean, there's so many million variables, and the problem is, ultimately, even if your property meets every single specific code, there's still a catch-all in the code saying, well, you also should, try to make your property safer, even if it meets all of these codes written down. There's some way to make it safer. You should make it safer. And so these guys always throw that one in at the end, which is just so ridiculous and frustrating. Okay, that's the state of the law on open and obvious. I do not know how much longer this will last. Michigan has an elected judiciary in the state court system. From the lowest judge to the highest judge of the Supreme Court, they're all elected. And there's been all this talk that we now have a very plaintiff-friendly Supreme Court, and we do, and it's where they're giving horrible rulings, they're making up stuff, in my humble opinion. But right now, the open and obvious defense has long been considered, that's going to be next. They're going to take away the open and obvious defense, or at least make it where it's not a case killer. It'll be a comparative issue, or a comparative negligence issue for the jury, blah, 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 blah. Well, just 2 months ago now, the Supreme Court issued an order in Becker versus Enterprise, where they specifically wanted supplemental briefing on the open and obvious issue, because everyone believes they're going to be addressing this. Number one, whether or not the open and obvious issue will be reduced to a simple comparative negligence issue, or if it will always be ruled a jury question. I don't know. I think they're going to take a lot of the teeth out of it. This is just my guess. And I'm also guessing that they'll reduce it to typically a fact question for a jury, so it won't be gone totally, because it'll always be a comparative negligence issue, right? Should you have seen it? Should you have done something differently? At the very least, it's that. And in Michigan, we have a statute for modified comparative, meaning if a plaintiff is more than half at fault, more than 50% at fault for their own injury, and they're not intoxicated, not drunk, not high, that statute says, well, they can't recover any non-economic damages, i.e. no pain and suffering. They can still get their pro rata share of economic, which would be their wage loss and medical bills, if they're more than 50% at fault and not drunk. That's our statute, which has been around since 1996. There's another statute, another modified comparative statute since 96, which says that if the plaintiff is more than 50% responsible for their own injury and their injury is caused in whole or in part by their drunkenness or intoxication, then it's a complete case killer. So you still have that to fall back on. If it's an open obvious decision, you can say, hey, look, Judge, especially in my Vroman case, let's say open obvious wasn't a case killer, but under my Vroman case facts at the coffee shop I just showed you, all those things we just talked about that would have been my motion instead. Your Honor, she's clearly more than 50% at fault. The things within code, even if it's not in code, as the plaintiff's expert is trying to claw at, it doesn't change that open and obvious does apply, even though this is a jury question. But certainly, the plaintiff has a duty to take care for their own safety, watch where she's walking, avoid ... No one else tripped and fell, which sometimes helps, sometimes hurts you, like if someone else tripped and fell. And in this case, this gal there's just a step there. I myself have encountered it 100 or more times coming in and out of that place. Never had a problem, as did the hundreds of people that came in that night from the festival did. So, Michigan has a elected judiciary. If you're a Michigan citizen, vote. Very important. Always elections coming up. Thank you again for attending. If you have any questions at all, I'm always available. There's my email. There's my direct dial. Always feel free to reach out. We also, as you know, we have webinars on all sorts of subjects, no fault, and so on. If you want to get invitations to those or on those mailing lists for all our newsletters on premises liability, on auto neg, on Michigan PIP, and construction, and employment, and environmental, and so on, let me know. I'm happy to add all of you guys to it and everyone from your companies. Thanks again. Talk to you soon.